In our previous video lecture, we discussed the rules in the computation of the gross estate for unmarried decedent. Now, the rules in computing the gross estate is different when the decedent is a married one. Okay, so in this video, I will discuss how to apply taxation rules in computation of the estate tax due of married decedent for the unit learning outcome week 4 to 5. The determination of gross estate of a married decedent shall depend on the system of property relationship governing the spouses, which may be either absolute cumulative property, conjugal partnership of gains, and complete separation of property, and any other regime. So, this four, ito yung mga different types of property regime. When you say property regime, ito yung agreement or the laws or the rules that will provide provisions as to what are the properties na included sa conjugal or community properties and what are the properties na exclusive naman, exclusive to both the spouse. So, what are the rules in determining the property of relationship? Okay? So, una, yung properties nila will be considered to be part of the gross estate or community property or conjugal property or exclusive property. Okay? The first rule is based on agreement on marriage settlement. So, depende kung ano yung agreement nila on their marriage settlement. Or ito yung tinatawag natin na pre-nuptial agreement. Okay, whatever is their agreement as to whoever owns a particular property shall be followed kapag meron silang agreement on marriage settlement. Okay? Or in their marriage settlement. Or again, yung prenuptial agreement. Kapag wala namang agreement as to how the property shall be divided or as to who owns the property, the next option is kailan sila ikinasal. Okay? Kapag yung marriage nila or the wedding took place before August 3, 1988, then the property regime will be the conjugal partnership of gains. Kapag yung marriage naman took place on or starting August 3, 1988 onwards, the property regime that will be effective is absolute community of properties. Again, itong dalawang ito lang yung alternative. Ayan. The first rule is based on their agreement. So kapag wala naman silang agreement, then this rule shall apply based on the date of their marriage or the specific date that the marriage took place. Ayan. So, starting off with conjugal partnership of gains, a regime. Ayan. So, kapag conjugal partnership of gains yung naging regime nila dahil wala silang agreement, tapos kinasal sila before August 3, 1988, then by default, magiging conjugal partnership of gains yung mag-apply. Article 105, So, under the regime of conjugal partnership of gains, the husband and wife place in a common fund the proceeds, products, fruits, and income from their separate properties and those acquired by either or both spouses through their efforts or by chance. And upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouses shall be divided equally between them unless otherwise agreed in the marriage settlement. So lahat daw ng fruits or gains during the marriage, okay, both from the separate industry of both of the spouses or from the properties, separate or common properties of the spouses, okay, magiging conjugal properties daw yun. Kasi nga, conjugal partnership of gains are deemed to be the communion of all the gains and fruits, no, by reason of marriage or during marriage. Article 116, all property acquired during the marriage, whether the acquisition appears to have been made, contracted, or registered in the name of one or both spouses, is presumed to be conjugal unless the contrary is proved. So as a general rule, lahat daw ng properties na inacquire during the marriage, kahit na yung name, no, ng owner, or even if such a property acquisition appears to have been made, contracted, or registered to the name, no, of one, kahit sa isa lang sa kanila or sa kanilang dalawa, still, general rule, such property acquired is conjugal or property, unless contrary is proved. So what are the exclusive properties ba of each spouse under conjugal partnership gains? So the following items form part of the exclusive property of each spouse. Ito daw yung mga exclusive properties ng each spouse. Again, it is important for us to know what are the properties part as conjugal properties and what are the properties considered to be exclusive properties. Kasi yung magiging computation ng gross estate ng ating decedent, no, is based on the classification of the properties, whether conjugal or exclusive. Okay. Remember that the gross estate of the decedent, it will not include the exclusive property of the surviving spouse. Kaya it is really important for us to know if a property ba is conjugal, okay, or a property is exclusive to the spouse, okay, or surviving spouse, or to the decedent. So ito yon, yung mga exclusive property ng each spouse, that which is brought to the marriage as his or her own. So ito yung it means that yung mga properties nila na nag-exist na prior to their marriage, okay, such properties are exclusive property of each spouse. So kung mayroong bahay si husband before pa marriage, okay, so during marriage, yung house niya is considered to be an exclusive property of that husband. Kapag si wife naman mayroong car before pa yung marriage nila, so it means that such car, since it is already existing before the marriage, tawag dyan, brought to the marriage, then such car by the wife is considered to be an exclusive property of that wife. So that which each acquired during the marriage by gratuitous title through pure liberty, no, as an or liberality as an or as in donation and testate or intestate succession. So kapag meron daw silang na-acquire during sabi dito during their marriage, okay, by gratuitous title, so kapag during their marriage, okay, naka-acquire sila or nagkaroon sila ng property through a gratuitous title or by a gratuitous title, meaning it's either dinonate sa kanilang dalawa or by a testate or intestate succession, okay, or na-inherit nila during the marriage, then such property is the exclusive property of either the husband or the wife. That which is acquired by right of redemption, by barter or by exchange with property belonging to only one of the spouse. Okay? So kapag nagkaroon sila ng property tapos yung ginamit na property in acquiring such property is the exclusive property of each spouse, then such property acquired by barter, no, by exchange, no, or ito yung tinatawag natin na onerous acquisition of property, then the same also is considered to be an exclusive property of the spouse. That which is purchased with exclusive money of the wife or of the husband. So kapag merong exclusive na money si wife or si husband, kapag bumili sila ng property even during marriage, then such property is still, it's still part of the exclusive property of the wife or of the husband. Now, Article 117. So the following are conjugal partnership properties. So, una, those acquired by onerous title during the marriage at the expense of the common fund, whether the acquisition be for the partnership or any of one of the spouses. So, yun dang mga properties na na-acquire during marriage na yung gamit is yung or at the expense of the common fund. So, for example, meron silang common fund tapos part of that fund was used to purchase a property or another property. So kahit na yung pinurchase na property is nakapangalan sa kanilang dalawa to the partnership or to only one of them, still such property purchased is considered to be conjugal partnership or properties nilang dalawa yon. Number 2, those obtained from the labor, industry, work, or profession, or either or both of the spouses. So, during their marriage, kapag nagkaroon sila ng properties that they obtained from their labor, kapag nagtrabaho silang dalawa, tapos ginamit nila yung salary nila, or yung fruits or yung salary nila mismo, magiging conjugal properties yun during their marriage. Industry, ayan, so salaries pa rin. Work or profession, of either of both the spouses. So kapag merong income or mayroong things or properties na na-receive either of the spouse, due to their labor, industry, work or profession, then during marriage, then such is also part of the conjugal properties. So the fruits, natural, industrial, or civil, due or received during the marriage from the common property as well as net fruits from the exclusive property of each spouse. So remember, si spouse or each spouse, meron silang tinatawag na exclusive properties and meron din silang conjugal properties. So lahat ng fruits under conjugal partnership of gains, lahat ng fruits during their marriage, whether such fruit is from the exclusive property of each spouse or from the common property of the spouse or spouse sa kanilang dalawa, then such fruit will be considered as conjugal property. So again lahat ng fruits during marriage, whether such fruit from the common property or from the exclusive property of each spouse is considered to be a conjugal property. The share of either spouse in the hidden treasure which the law awards to the finder or owner of the property where the treasure is found. Ayan, kapag meron silang nakita na treasure, so part yun, during marriage, part yun ng kanilang conjugal properties. Those acquired through occupation such as fishing or hunting, livestock existing upon the resolution of the partnership in excess of the number of each kind brought to the marriage by either spouse, and those which are acquired by chance, such as winnings from gambling or betting. So kapag meron silang kapag nanalo sila sa, let's say, gambling or betting, so sa, let's say PCSO, ayan, so yung panalo nila will be part of the conjugal properties ng mag-asawa. However, kapag talo or losses therefrom shall be borne exclusively by the loser's spouse. Okay, so kapag talo naman yung natalo na property, let's say pera, pag natalo yon, it shall only be borne or shouldered exclusively by the loser spouse. So kung sino yung natalo, siya lang dapat yung mag-born, no, ng such a loss. Yan. Kapag panalo naman, okay, so such winnings shall be part or shall form part of their conjugal property. Okay? So that are no the properties or the rules. Those are the rules under conjugal property or conjugal partnership of gains and community. Okay? So yun yung magiging part or yun yung magiging rules, okay? Para yung properties, okay, ma-consider as exclusive property or conjugal properties ng spouse under conjugal partnership of gains na regime. So, the next regime is the absolute community of property. So, this is another type of regime. So, the absolute community of property between spouses starts from the time the marriage is celebrated. So, it starts down from the time the marriage is celebrated. Okay? So, it cannot be modified during the marriage. Hence, any agreement must be done prior to the contracting or prior to contracting the marriage. So that is under Article 88 of the Family Code. Under the regime, all properties owned by the spouses before the marriage and those that they acquire during the marriage shall form part of the absolute community and is shared equally by husband and wife. As a general rule, lahat ng properties owned by the spouses before the marriage. So kung meron na silang mga properties before or prior pa sa marriage nila, and lahat ng properties na na-acquire nila during marriage shall form part of the absolute community and is shared equally by husband and wife. That is the general rule. Ayan. So lahat ng properties nila before and during the marriage, magiging part yon ng community properties ng mag-asawa. So kung part yun lahat, ano naman yung magiging exclusive properties ng each spouse? As a general rule, any property acquired during the marriage is presumed to belong to the community or sa kanilang dalawa, unless it is shown that it is excluded in the following. So property acquired, so ito yung exemption. Ayan. So if such a property is included in these items, then such property will be considered to be an exclusive property of each spouse under absolute community of property regime. So, number 1, property acquired during the marriage by gratuitous title, such as by way of donation or inheritance, unless the donor, testator, or grantor provides that they shall form part of the community property. So, just like conjugal partnership of gains, under community or absolute community of properties, kapag si husband and wife, okay, naka-receive ng properties gratuitously or by gratuitous title, meaning it's either dinonate sa kanila or na-receive nila by a succession, then such property will be part of their exclusive property, not of their community property. So this rule is also applicable in under conjugal partnership of gains. Okay? So unless sinabi ng donor kapag dinonate yun or ng testator kapag na-receive nila yun by succession, nasa kanilang dalawa yun, then such property will form part of the community property. Okay? So if one of the spouses inherited a property during the marriage, his or future spouse will not co-own that property as well as the fruits and income therefrom. So ito yung tinatawag na fruit follow principle. So it means that kapag isa sa kanila or kapag isa sa mag-asawa naka-receive ng property via gratuitous title, then again such property received shall form part of the exclusive property sa spouse na kung sino man yung naka-receive nun. Okay? Kaya meron tayong rule na fruits, no, follow principal. So therefore, that kapag yung property na na-receive ng isang spouse, okay, by a gratuitous title is nagkaroon ng fruit in the future, then such fruits of the property received by a gratuitous title shall also form part of the exclusive property of the spouse who received that property. Kaya, tinatawag natin na rule dyan, again, is fruits follow principal. Property for personal and exclusive use of either spouse. So, ano-ano ba yon? So, yung mga personal property na yung makakagamit lang is one of the spouse. For example, tuxedo. So, yung makakagamit lang ng tuxedo is the husband. So, that is the property of the husband. Okay, personal property ng husband. Kaya, part yan ng kanyang exclusive property. Kahit pa, property na niya yan before the marriage or during the marriage. Gowns. Gowns, syempre, sa asawa yon. So, therefore, that is the personal property of the wife. Therefore, magiging exclusive property yon ng wife. Kahit na na-acquire niya yon before or during marriage. Except jewelry. Kasi kahit na yung jewelry is a personal property of either of the spouse, still jewelry would, in a general rule, considered to be part of the community property. It is not considered as excluded, no, under this. Hence, it is part of the community property yan. Okay? So, si jewelry lang yung exclusion sa general rule na yung personal properties ng spouse is part ng exclusive property niya, except jewelry. Kasi again, jewelry will form part of the community property. Property acquired before the marriage if the acquiring party has legitimate descendants, children or grandchildren by a former marriage. So the fruits and income of such property are also excluded. Okay? So kapag si one of the spouse, meron siyang descendants, no? Let's say meron siyang children, meron siyang mga anak, or meron siyang grandchildren sa prior marriage niya, then lahat ng properties niya before the marriage will form part of his exclusive property. It will not form part of that partners or spouse community property. Okay, so anong purpose niyan? So the purpose of that, no, sabi ng family code is to protect the right of the descendants, no, or those or the children or grandchildren ng isang spouse prior to or from his or her former marriage, no, to protect their rights. Ayan. So ano naman yung mga communal, no, or community property ng spouses kapag yung regime is absolute community of properties. So unless provided in the family code or in the marriage settlements, the communal property shall consist of all the properties, all the properties owned by the spouse at the time of the celebration of the marriage or acquired thereafter. So lahat daw ng properties prior to the marriage and lahat ng properties na na-acquire during the marriage, part yun ng community property ng mag-asawa unless excluded siya. Okay? Based on these rules. Ayan. Property acquired during marriage is presumed to belong to the community unless it is proved that it is one of those excluded therefrom. So ito yung summary of rules. Okay, property relationship between spouses. Ayan. So, first, okay, so meron tayo ditong dalawang regime. Ito yung conjugal partnership and absolute community. So, property acquired before marriage. So, ito yung mga properties na na-acquire nila prior to their marriage pa. Okay? Kapag yung property was acquired gratuitously, exclusive property yan ng spouse, okay, na nag-acquire niyan under conjugal partnership. Under absolute community naman, that is communal property nilang dalawa. Kapag onerous naman, okay, under conjugal partnership, exclusive pa rin yung property na na-acquire in an onerous title. Under absolute community, communal yan. So remember na kapag conjugal partnership of gains yung property regime nila, lahat ng properties nila before marriage is part yun ng exclusive properties or exclusive property yun nila. Kaya hindi magmamatter kung gratuitous ba yan or onerous ba yan na na-acquire nila. Okay? Kasi nga, lahat ng properties nila under conjugal partnership of gains, exclusive yon. Lahat ng properties before marriage. Again, it doesn't matter kapag or kahit gratuitous or onerous yan. Okay? Under absolute community properties naman, remember, lahat ng properties niya before the marriage or those properties brought to the marriage is part of the community property. So kahit na under absolute community of property, kahit na gratuitous or onerous yan na na-acquire, basta na-acquire yan siya before marriage, part yan ng kanilang community property. Okay, where the spouse has a legitimate descendant from a previous marriage. Ayan. So kapag what happens naman daw kapag yung property niya is a property na niya before marriage, tapos yung spouse na yon has a legitimate descendant from a previous marriage. Again, it doesn't matter under conjugal partnership kasi lahat ng properties niya before marriage is exclusive yon. Exclusive property niya yon. Under absolute community of property naman, lahat ng properties niya before and after marriage is part yon ng community property niya. Okay? Unless yung property na yon is unless yung property na yon is or yung spouse, okay, ay meron siyang legitimate descendant from a previous marriage. Ayan. So yung property niya before the marriage is exclusive. Okay? Magiging exclusive lang again yung property niya before marriage kapag yung spouse ay mayroong legitimate descendant from previous marriage. Okay? Now, number 2, let's talk about properties naman na na-acquired during marriage. So, kasal na sila. Okay? So, ano ba yung mga classifications ng mga properties nila? Ayan. Now, kapag yung property, during marriage na tayo kapag yung property was acquired in a gratuitous or by gratuitous title, both under conjugal and absolute community of properties regime, magiging exclusive yon. Okay? Again, kapag yung properties are acquired by a gratuitous title, it's either dinonate siya or na-receive nila by succession, both regimes, or under both regimes, exclusive properties yon ng spouse na naka-receive. Kapag na-acquire naman nila yon by an onerous title, so binili nila, there is a consideration upon acquisition, under conjugal and under absolute community, conjugal and community properties nilang dalawa yon. In exchange for exclusive property, ayan, so kapag binili nila yon or na-acquire nila yung property na yon during marriage using their exclusive property, then magiging exclusive properties din nila yon under both property regimes. Exclusive yon. In exchange for conjugal or community property, okay, then under both regimes, conjugal and community din, communal properties din nila yon. Now, kapag yung what are the fruits naman or how to treat the fruits or income from exclusive property? Ayan. So, yung fruits or income from exclusive property na na-receive nila during marriage, under conjugal partnership of gains, yung fruit na yon is conjugal. Remember, lahat ng fruits na na-receive, okay, ng spouse, okay, during marriage will form part of the conjugal partnership or will form part of the conjugal properties of the spouse if the regime is under conjugal partnership of gains. Ayan. Kasi nga, it is considered to be a communion of their fruits, okay, during marriage. Under absolute community of properties naman, the fruit follows the principal. Kaya, kapag yung fruit is from the exclusive property, exclusive din siya under absolute community of properties. Exclusive property din siya. Kapag yung fruit naman is from a communal or community property, then yung fruit na yun will also form part of the communal property. Okay? So, eto na siya. Fruits or income from conjugal or community property. It doesn't matter nga under conjugal partnership of gains kasi lahat ng fruits na na-receive during marriage, whether from exclusive property or conjugal properties, ay magiging conjugal properties nila yan. Pero under sa absolute community properties na property regime, the fruit follows principal. Kapag yung fruit is fruit from a communal property or community property, din magiging communal property din nila yun. Kapag yung fruit naman is from the exclusive property of the spouse, then magiging exclusive property ng spouse yung fruit na yun. So the highlighted rows are the differences between the two systems. Ayan. So ito lang yung magiging difference nila. Okay? Yung mga naka-highlighted na rows. Jewelry shall form part of the communal property in case of absolute community. So magmamatter lang or magdi-differ lang si jewelry. Kanino bang property si jewelry kapag yung property regime is absolute community of property. Kasi under absolute community of property, si jewelry is part of the communal property or community property. Okay, so that's it for the rules on the classification of properties. Conjugal ba siya or exclusive ba siya under conjugal partnership of gains? Or communal ba siya or exclusive property ba siya under absolute community of property? Again, it is very important for us to know the rules and the classifications of the property if the decedent is a married decedent. Kasi nga, yung subject lang sa estate tax are the properties lang exclusive properties lang ni decedent plus the share of that decedent in the conjugal or communal properties. Okay? So, hindi mo papatawan ng estate tax yung share ni surviving spouse sa communal or conjugal property nila at yung exclusive property ni surviving spouse. Hindi yun part ng estate taxation. Okay. So, illustration will be explained in the next video.